Right, hello everybody, and first of all, thanks a lot for organising this conference and thanks a lot for inviting me. I think you've hit a really, really important, difficult, messy area where I think we've not got some great answers to some very, very difficult questions yet. I think we all understand freedom of speech, we all understand privacy, and we want both. That's good, we all understand that. But the problem that we've got as a regulator is that while we can understand privacy, freedom of speech and these kind of big structural things, we have to make actual decisions about real cases involving real people. So, for example, when somebody, a member of the public, objects to what is presented when you Google their name, up comes all sorts of defamatory, negative, unpleasant comment, maybe true, maybe not true, we don't know. We have to make an actual decision, do we order Google to take this stuff down or not? And to do that depends on policy, it depends on rules, it depends on developing criteria, it depends on working with the industry to get to a reasonable standard. But that's where regulators kind of differ from academia in that we do actually have to say, does this result stay up or does it come down? And we also need to put our money where our mouth is. And if Google say no, go away, or Microsoft Bing say no, go away, do we enforce over it? Do we fine them? Do we go through the courts? So there's a kind of empirical sort of tough edge to what we do, which kind of moves some of this debate on a little bit. I think there are some really difficult issues here in this whole space of social media and privacy, and I don't think we should assume we can get this lovely proportionate balance we're always hearing about. I think as societies develop, there are shifts in terms of access to information, there are shifts in terms of privacy, and maybe we do need to recognise that we're entering an era where in reality it gets easier and easier for us to say horrible things about each other and more difficult to stop it. Now, there are things you could do, but some of the solutions are kind of really, really difficult. For example, you could have a lexicon of banned words, some of the ones we just saw in your presentation there. These are very, very easily identifiable through DPI techniques and so forth. And the police intelligence services use this all the time to detect websites and content about how to make chemical weapons and all this kind of stuff. It happens all the time, stuff's taken down all the time. We've certainly got the technology to find hate messages and to find hateful postings on Facebook, although no doubt people would develop a new kind of vocabulary to get around that. But there are solutions like that, but I think they're kind of frightening, and I think we really need to think where we're trying to go as a society in terms of policing this whole area. I think there's also a whole piece around the basis on which we use internet services. I think we generally like anonymity. We generally like relatively unintrusive forms of identifiers, such as aliases. It would certainly get a lot easier to catch bad people saying horrible things on the internet if we knew who everybody was. Again, is that the paradigm we want to try and get towards? That, again, is frightening. And I think most of us who use the internet, who care about the internet, like the idea that we can use services, we can access services without providing really, really hard physical identifiers. In some countries it's very different, but here, and in the US too, we kind of like that, and I don't think we want to lose that. So how we balance anonymity with catching bad people is obviously a classical big problem area. I think probably the best we can get to, and I'll talk a bit about the work we've done on Right to be Forgotten with some of the search engines, is some cleaning up of some of the worst content to make it much more difficult to find. That's probably the best you can get. And we've had some success working with the search engines in doing that, which I'll talk a bit more about in a minute. But I think it's also, there are some really deeply held views about this whole area. And if you talk, for example, to the BBC, some of whose content has been, the links to it have been delisted from Google, Bing, other places, they see their news archive as this really kind of important, holy of holies thing. And I'm very sympathetic. It's a bit like the British Library of News. They want all their news stories to be preserved, to be searchable, as a kind of public interest resource, as a kind of academic resource, as a historical record of society. And I think we at the IC are really, really sympathetic to that. We can see the beauty of that. But obviously that's got real privacy impact on people. For example, when you Google my name and you find it's a 15-year-old story about shoplifting, should you be able to find it that easily or not, which is what the dilemma we've kind of got at the ICO. You probably all know what data protection is. That's it, a set of rights, purpose limitation over what people could do with information about you. It applies to all processing of personal data, so that includes social media postings that identify people, and it also includes journalism. There are very, very powerful and complex provisions in data protection law to do with protecting the rights of journalists to report stories. And back in the day, a journalist was a member of the NUJ, they worked for the Daily Mirror, they worked for a magazine, you knew who they were. It was very much like a model, a bit like in some less free societies where you get accredited journalists who are the only ones who are actually allowed to carry out journalistic activity, a place like Iran. But it's all different now. We have citizen bloggers, we all report all the time on things we see, and whether informal, private, citizen-type journalism should have the same kind of protections as it were official journalism is something I think is unresolved. Certainly at the ICO we've sort of recognised the legitimacy of blogging, the legitimacy of kind of private citizen journalists. That's the direction of travel. So that means that it's difficult for to police social media, because those same exemptions that can apply to Daily Mirror journalists, we think can also apply to private citizens saying things which they believe to be newsworthy, even difficult things on social media platforms. So there are a whole load of tensions here. And there's a whole separate, complex, messy piece around the role of publishers, content publishers, search engines who help you find the stuff, and individuals who actually post the stuff. And I think if you look at some of the recent court decisions, both in the UK and in Europe about this, I think it's been a bit of a cop-out in some ways for the publishers and the individuals who actually post this horrible stuff in the first place. And a lot of the attention has been on the search engines who make it available to you. And some of the problems, we've seen lots of examples today of problematic content, and the guilty party is probably primarily the person who posts it, not Google for making it available. So there's all sorts of issues there, and some kind of quite perverse and unfair outcomes, I personally think, in terms of the responsibility of content publishers, search engines and individuals. And sometimes it's all got very, very messy and mixed up in terms of who is liable and who's responsible for what. And I think that's kind of unresolved. Yeah, social media, it certainly involves personal data, so it comes within the scope of data protection legislation. It must be fair to say that over the years we've kind of fudged this as data protection authorities, and we didn't really like the conclusion that Bing or Yahoo had to ensure the accuracy of all the information that they host on their servers. It's impossible. It's a ludicrous thing to ask them to do. It just doesn't fit modern reality. There are those who say, well, they've got lots of money, they should be checking everything, but in reality, that's never going to happen. So there are all sorts of issues about the limitations of current data protection law as a protection for citizens who are the victims of social media campaigning. I think also there have been some quite challenging CJEU decisions in this area. A few years ago, the Theodore Lindquist case, which basically said that if you have an open Facebook page and anyone in the world can access it, or any Facebook user, it can't be done for personal reasons, so you lose all the protections around personal free speech, which data protection law is supposed to give you. So there have been some kind of difficult and challenging cases, and the Google Costea judgment, which led to all the hoo-ha over the right to be forgotten in terms of delisting search engine results, came out of a similarly kind of difficult decision, I think. Yeah, I mean, the courts have made it clear, though, that the technology companies, the search engines, the social media sites, have got data protection liabilities. They are data controllers under the law and have to obey the rules. But that clearly needs to be in a kind of modified way. We're never going to get to the position where Yahoo check the accuracy of all the search results they host. I think probably the best you can get to, and we've had some success with this, most of the activities have been around Google, because that's the biggest search engine and so forth. But they've actually been pretty good. They've taken down, according to their own figures at the end of last year, links to 1.2 million dodgy website stories, mainly social media. And when we do decisions on particular cases, we draw a distinction between kind of more serious journalism, which is a public interest, and somebody who set up a fake website just to be horrible to somebody. So we try and do those distinctions, and we try and draw a kind of a private personal distinction. Going back to the case of Dan Yock we were talking about earlier, clearly an MP, significant public figure, and we would bear that in mind in deciding whether to delist a case, a search result like that. So we draw these distinctions, which are very much more kind of arts than sciences, I would say. But on the whole, we've come to reasonable decisions. And on the whole, when we say to Google, can you take that search result down? On the whole, they do. There have been some cases, but very few where they haven't. But those go through another more formal stage of the process. It's also interesting, and I can't really talk for the industry, but I think their attitude has been quite interesting. I think going back a few years with this kind of West Coast fundamentalism that you do not mess with the internet at all, you do not moderate content in any way, it's a kind of free-for-all. I think that's really moved on. And I think all the responsible companies would recognise that there are clearly links to stories and there's clearly content which is causing a huge amount of negative impact, or having a huge amount of negative impact on ordinary private citizens who aren't in the public eye, who don't have a significant role in society, and who are just having their lives ruined because people have been trolling them and setting up fake book accounts and all the things that people do. So they've been taking tons of this stuff down. We get actually relatively few complaints about it, which suggests that either people can't be bothered to complain to us, or they're reasonably happy with the result they get from contacting the technology companies themselves. In terms of what we tried to do ourselves, recognise the importance of freedom of expression, recognise the difference between different types of platform in terms of editorial control and liability. There are clearly some sites that are essentially just walls that people put messages on. There's no editorial supervision at all, and I think those sites are kind of different to ones where there is editorial supervision. A good example was a company that was running Solicitors from Hell website, it was called, and they also had, to be fair, a Solicitors from Heaven website. But they were basically putting horrible content up on behalf of people who didn't like the solicitors, and charging solicitors to have it taken down again. So it was clearly being run as a business with editorial control, so we went after them and basically shut it down. We have taken action. We get lots of ones about really quite nasty kids saying things about their teachers. But again, this kind of touches on some really old and difficult issues of freedom of speech. If you're a kid and you think your teacher's awful, why shouldn't you be able to say that? You know, and we're very sympathetic to that. But to try and get these balances right, I think is getting increasingly difficult. I think we've recognised the impossibility of trying to apply all the principles of data protection, all the accuracy rules, all the relevance rules, all the out-of-dateness rules. Information can't be out of date, it's got to be up to date, to all the information that's hosted by UK or even global data controls on the internet. So we kind of pick our fights carefully, I guess. And I think probably the great white hope here really is to encourage better privacy tools and industry best practice, which you've heard a bit about that earlier in the session this morning, and better ways of closing accounts down. All the right to be forgotten stuff really came out of the fact that at one time it was almost impossible to shut down a Facebook account. So that's going to be coming in formally in data protection law in about 2 years' time. We're getting new data protection law across Europe. So I think that we've been reasonably successful in engaging with the industry to try and get it easier to have content removed, better reporting systems for when somebody sets up a fake Facebook account in your name and says horrible things and posts horrible images. Although there are all sorts of issues there about identifying the real complainant, who they are, and all this kind of difficult stuff around identity management, which is unresolved, I think. We've also recognised that libel, slander, freedom of expression has a long history, and standards change. Apparently libel comes from libello, which are these little inflammatory booklets that Italians used to give each other in the Middle Ages. And there's a real history of that, and if you look at England in the 18th century, people like Lawrence Sterne, the novelist, was handing out appallingly horrible leaflets about other novelists. Smollett was his enemy, apparently. So kind of standards change, and I think, you think about some countries in Eastern Europe where you used to have you needed a license for a typewriter because the regimes were so scared of people producing and disseminating anti-regime propaganda. From one extreme like that, or where the internet is, you basically have a North Korean version of the internet or nothing, you know, there's a big spectrum and standards change, and I think we're in a period of real flux here in terms of how we police all this, what we can actually offer to citizens in terms of defending their privacy rights. And maybe we cannot stop this anymore. Maybe we can be very, very limited in what we can do. Maybe we need to recognise that and find some other approach. The role of search facilities is very important, and if you look at, again, organisations like the BBC, the vast majority of their content is now accessed through a search engine, not through the BBC-owned search facility or through reading a newspaper in the old-fashioned way. So the search engines are critical in all this. And, you know, as you've probably heard, I don't think the existing law works very well. I think there's some big holes, and maybe we should look at something new. And in terms of us as a regulator, our exemption around freedom of speech and journalism involves us disproving a reasonable belief in the public interest of publishing, and that's very, very difficult to do. Right, all the American technology companies, they're all there. So do kind of get our newsletter if you can, which tells you what we're doing. There's going to be lots and lots of data protection news and change over the next few years, so it's very much in our interest to follow this story. Okay, thanks a lot, everyone.